Well, I appreciate being here. This is my second time coming to the Confluence. I was coming to it is the Confluence. I think we used to call it the Symposium, right? That's how long ago it was that I came here, and so it's great to be here. I want to build a little bit on Marcel's presentation here. She mentioned saved water change applications a few times, and so I plan on talking about that for a little bit. And what I really want to do is build on the why. Why is that important? Why such a boring topic, right? It's water rights. I mean, some of us spend our entire career on this, but some of us work really hard to avoid water rights because it's this black hole of legal and engineering and all of that. So. We good here? Just up a little higher? Okay, how's that? Better? Okay. So I know from the past here that we get kind of a mix of different people. We get some water users and producers, and then we also get a lot of conservation-minded people, and we get engineers and some lawyers, and so I hope there's different parts of my presentation that kind of touch each of those different concerns. I think I'll just try and hopefully build the case for why this is important and give you a little bit of background. So these are some of the topics that I'm going to touch on. We have an ongoing procedure, or this Great Salt Lake distribution plan that I'd like to touch on a little bit and use that as the means to kind of convey why the rest of my presentation is important. And I think Marcel touched on a little bit of this. She talked about, in some of her work, needing to file these change applications. And the reason that's important is because you can conserve and conserve, but if you don't file the change application and dedicate it to the Great Salt Lake, and it's not even limited to the Great Salt Lake, but if you don't take those efforts and run that application through our office, then there's no guarantee that water's actually going to get there. And so hopefully I'll build that case and you'll understand that. So after that, I'll talk about all the change application basics and history. We're going to do some history and then talk about how to implement a saved water change application. And then if we have time, if I get through this soon enough, then I'll take some questions. All right, so this Great Salt Lake distribution management plan is something that was mandated by the legislature last year, and we were given a deadline, a very very stringent deadline to get this thing in place. So it directs us, it orders us to develop a Great Salt Lake distribution management plan. Now, the reason that the legislature felt that this needed to happen was because the state was expending so much money towards the Great Salt Lake, and they were concerned that perhaps without a plan in place that those waters weren't being accounted appropriately. Historically, the state kind of operated like the Great Salt Lake was just kind of this thing at the bottom of all these hydrologic basins, and there was very little concern with what was happening there. Obviously, we're in a different world now, and so the legislature wants us to be able to identify and protect the water that's dedicated to the Great Salt Lake. In developing this plan, you can see all the criteria that we need to evaluate. Hydrology, the lake elevation, so this thing should hypothetically vary according to the elevation, the salinity level, all of these different things. It asks us to develop a priority schedule. So in the state of Utah, water is distributed according to priority date, when you first place the water to use. And so that's the doctrine of prior appropriation. I'll talk a little bit more about this later on, but that doctrine applies to the Great Salt Lake too. Earlier water rights function differently than later priority water rights. And then we're developing tools that will help support all of this. So this effort is underway. There was a public meeting in October where we jump-started the plan development process. There was a period of comment. It's ended, but I'm sure if you really wanted to comment, we wouldn't turn it away. So So feel free to comment if that's something you'd like to do. The legislation placed on us the duty to have this plan adopted by October of 2025. So we're on the clock and we're moving our way through this. If you're interested, we all like QR codes, right? And so I'll leave this up here for a minute. This is a web page that we've set up to convey information about this throughout the coming year as we move towards final adoption. And so feel free to take a picture and interface with that if you'd like. On that website, you'll find a listing of water rights that are dedicated to the Great Salt Lake and have filed change applications. Okay, so that may be of interest to you. Okay, so let's jump into change applications. And we're going to start going way back in time, pre-statehood. And the reason I want to do this is, again, just to support this idea of saved water, whether you have an asset that you're trying to optimize, you're a producer, or whether you are part of a conservation group, you're looking to define and dedicate water to the Great Salt Lake. There's lots of different reasons you might be interested in this. So many of you know the story of development in Utah. Obviously, indigenous peoples were living here long before many of us or our ancestors came in. Things really kind of get jump-started in 1847 with the arrival of the Mormon settlers. Trappers and fur traders had come through, of course, but 1847 is what we celebrate, Days of 47 and whatnot. So in the early days of statehood, appropriation really dominated how water was put to use. You went and you took the water and you placed it to use. When you go and look at the records, and we just finished this in the Salt Lake Valley, but you can see that they very rapidly placed all of the primary waters to use within the next year. And so Parley's, Mill Creek, Big Cottonwood, Little Cottonwood were all diverted and being used by the very next year, 1848. Now I'm here in Weber County, so let's talk about that a little bit. It's a little bit different and maybe a little bit slower. Trappers were here prior to 1847. The very earliest water rights in this system seem to be from like the 1848 period. Development extended up into the mountain valleys later on, and really kind of picked up and accelerated into the 1850s and 1860s, and then the railroad comes through and just everything blows up and goes crazy. So I've already mentioned this, but the Utah water law from the very earliest days functions on the doctrine of prior appropriation, and that's sometimes kind of summarized as first in time, first in right. You get there, you place the water to use, and you now have a water right. In the days before statehood, maybe that functioned as you just went and you placed a notice on a tree nearby your diversion. But anyways, through this course of things, most of the primary sources in the most populated areas were appropriated by 1880. And this is, again, if you know your Utah dates, then this is long before statehood still, okay? All the water was appropriated in the territorial days. So all this water being appropriated, what about changes? Water uses don't just stay the way they are. People need to be able to adjust and tweak, and instead of taking it here and doing this, I'm going to go and take it over here and do this different thing. So the 1880 territorial laws recognized that if you possessed a water right, you also had the right to change it without affecting the validity of the water right. Okay, but this is maybe the basics here, but we're missing a lot of pieces, because how does it interact with other water rights? Well, as we developed here, we move on to the statehood period, and we have the framing of the Utah Constitution. The framers were really concerned with the possible confiscation of existing water rights, and so they include in Article 17 the only reference to water rights in the Constitution, and that is that existing rights to the use of waters in this state for any useful or beneficial purpose are hereby recognized and confirmed. Okay, and so the focus was to basically define this principle that if it existed prior to statehood, the right was valid, it was good, it was solid. Okay. Let me see if I'm covering everyone with everything I want to do here. All right. So with statehood also, the state engineer's office was set up and was created in 1897, as you can see from my slide. Initially, the state engineer wasn't given any authority over water rights, and was really just tasked with creating hydrographic surveys and doing measurements, stream measurements, and so very very limited role initially. That began to change. There was a key court case during this period that started to lay the foundations of how change applications would function. What happens when you want to change it? And the court case dealt with someone that wanted to move a diversion point from below a mill to above a mill. And clearly that has an effect on the mill. They took him to the Supreme Court, Utah Supreme Court, and the Supreme Court lays out this principle that sure, you can file a change, you can move a water right, you can change it, but you can't impair other water users, you can't injure them. Okay, so as we move on in time, anyone that's familiar with water rights knows that we put a lot of importance on this 1903 date. This is the year that we got our first water statutes. And the vision of these statutes was that the state engineer would then begin to oversee all new appropriations of water, and that anything that had been in place prior to statehood or even prior to 1903 would be quickly adjudicated and brought onto the records. And the existing rights would retain all of their vested rights, including the right to make changes if they wanted to. And the state engineer gained one of the first authorities that they had, and that was to oversee appropriations. But when it comes to change applications, the state engineer was limited. There was only this requirement to provide notice to the state engineer of a change. So kind of just a record-keeping responsibility. And now it did lock in that principle that the Supreme Court talked about, and that changes can't impair other water right holders. So that's the 1903 statute. Well, anyone familiar with the judicial system knows that there's nothing quick about the judicial process. And so it didn't turn out to be the most successful. And again, some of my frame of reference here is Salt Lake County, and I'll tie this into Weber County as well. But you see in this time period a quick succession of adjudications of these key streams, trying to follow this vision. And so you can see the name Morse. Judge Morse was very active in this time frame. And so the Jordan River had a couple different court decisions in the Little Cottonwood Creek in 1910, Parley's Creek in 1912, and Mill Creek and Big Cottonwood Creek. So notice I haven't included anything in Weber County. Weber County was fortunate enough or unfortunate enough to be put off a little bit later. And as things developed there, they saw that this needed to be done a little bit differently. This was going to take forever. And so the Ogden and Weber rivers were subject to one of the first comprehensive adjudications, general stream adjudications, and that results in the Ogden and the Weber River decrees. But even those took until the 30s and the 40s to get done. They started in the 20s. So big change in 1909 is they recognized that the state engineer needed to have a role in these change applications. The courts were not capable of overseeing all of these changes throughout the entire state. And so with the 1909 statute, the state engineer was given authority over change applications. You needed to make an application, and that the state engineer would be reviewing these water rights or these change applications for impairment. So we have a long track record of applications throughout the state, and I'm running out of time, so I'm going to rush through a few of these. This is some of the number of applications that we've looked at. I want to jump in real quickly to some change application basics. And this is all defined in statute. And so I may skip a little bit of this, but I've covered a little bit of this. So that foundation that we see established in those early years, in the early 1900s, is carried through to today. Change applications today are subject to non-impairment of existing water rights. And when you come and make a change application, you bear the burden of producing evidence that the change can be made. And let's move along here. And then the state engineer, as part of her evaluation, has various criteria that we need to use to evaluate them. And so you can see some of those. An important takeaway from this slide is that the state engineer operates under what's called a reason to believe standard. If you're convicted of a crime, your jury is going to evaluate you based on, what is the phrase? I just forgot it. Reason? No, if you're convicted of a murder, that's not it. But anyways, it's a lot higher standard. The standard for change applications is down here. We just need to have a reason to believe it. All right, and let's move along here. So change applications come in a lot of different flavors. This is glorious if you like ice cream. If you're lactose intolerant, this is a nightmare. So changes on perfected water rights, applications to appropriate, changes on shares. Some of the more recent things is in-stream flow change applications and split season change applications, which was added in 2020. And the most recent that I want to take the last little bit of time on is saved water change applications, which was added just last year. So I might spend the most time on here just to help you understand. So the statute is written with some key words, and it defines saved water as the net decrease in depletion or the net reduction in diversion for a perfected water right resulting from an agricultural water optimization project. So what those words and what that word net means is we're looking for, under the saved water statute, where we're looking for actual real reductions in water use. Okay, and so there's not going to be any benchmark crop of alfalfa if you weren't growing alfalfa. If you're growing something else, that's now going to be your benchmark. And so when you come in with a change application, expect to be viewed that way. We're going to need to see additional measurements and information to be able to support a saved water change application. So where do I even start? Come and talk with us. We are happy to do pre-filing consultations with anyone that is interested in doing these change applications. How precise do you have to be? An idea is sufficient at first, and that's fine. You can just think about, have an idea of what you might want to do to optimize this. Mixing flavors is okay. Split season plus an in-stream. Not mixing is okay too. If you don't want to, you can just define a quantity of water that you're going to save and conserve. What to expect? You're gonna need to provide measurements. We're gonna need to be able to track those savings. Again, the focus is on net conservation, and so we want to actually measure it and see it if we're going to do this. And the impairment, of course, is an ever-present thing. What can they be used for? Saved water it's split into two things: depletion savings. Maybe you can expand on a less consumptive crop. Maybe you can market to other water users, environmental purposes, dedicating to the Great Salt Lake, or anything else you can think of. Diversion savings are a little bit more difficult. Diversion savings are limited to non-consumptive uses. And there's one last slide here is an important note here. It's an easy confusion to make when you're reading the statute is involvement in one of these programs, like Hannah was here talking about the Ag Optimization Program. It's not required to file a saved water change application. I know we probably don't have Colorado River people here, but it's another state-funded program that talks about this. But you can file your own saved water change application for your own purposes, or you can participate in one of these. You may, if you decide to participate in that. So that's kind of a sum of it. I know a very quick overview of saved water, but hopefully that gave you a couple tidbits, and happy to take some questions if there are any. All right, so the question was how this connects with water banks. They're similar, but not exactly the same. And I think conceivably it's one of these flavors that you could mix if you wanted to. A bank could take water into it and then use it for, well, it can already use it for conservation purposes, but you might couple it up with saved water. So certainly, yeah. But again, the gateway to be able to do this and get credit and to have it recognized on the system is filing the change application. Okay, thank you.